Well, hello all Second Amendment lovers and freedom lovers. On this video, I want to talk about the court case, the Supreme Court case that as of November 3rd, Wednesday, the last Wednesday, the Supreme Court hearings was completed in New York City. And I want to start basically with the email that I received about this court case from NRA. And as you can see here, it says that this Wednesday, November 3rd, the Supreme Court will hear oral arguments in the NRA-backed case, New York State Rifle and Pistol Association versus Bruen. This is the first Second Amendment related case that the U.S. Supreme Court has agreed to hear in over a decade, and it is entered around whether or not a special need is required for law-abiding citizens to be able to exercise their right to bear arms. So basically, this hearing at the Supreme Court level was about the special case clause that they propose. What that tells us, what this law or what this proposal was entailing, was that a person who is applying for a permit to carry, a concealed carry or open carry, is supposed to prove a special need, and unless that special need is agreed upon by the authorities, this person wouldn't be able to acquire a permit, therefore wouldn't be able to carry a concealed carry weapon, on his person or on her person. Without any explanation, obviously, this is an extreme violation of constitutional rights of law-abiding American citizens. There is no such thing in the Constitution that is limiting a citizen to carry a firearm based subject to some kind of a special need. Any law-abiding American citizen by Constitution is guaranteed, I repeat, the guaranteed right to carry firearm on his or her person, given the age limit of 21, and of course, subject to background check. So now I'm going to go to the article that is directly related to this case, which was which appeared and published on Newsweek. So now I just want to kind of go through this argument. This article, which is covering and bringing the commentary analyses on this Supreme Court ruling. SCOTUS, which is Supreme Court of the United States, Second Amendment hearing signals justices think that there are too many gun control laws. So let's see how the argument goes here. So, apologize. I don't know what. I hope I'm not going down with something else. All right. The Supreme Court took up its first major Second Amendment case in over a decade on Wednesday, November 3rd. And while the justices' questions suggested that New York's law is likely to be stricken down, they also signaled that they think gun control laws are excessive not only in that state, in New York State, but across the nation, which is awesome outcome of this Supreme Court hearing. This case signaled that not only the court's growing hostility to restrictions on concealed carry, the subject matter of today's case, but reflects the view of some justices that there are too many gun control laws and that we need to start striking gun control laws down, UCLA law professor Adam Winkler told Newsweek. a significant portion of the gun safety movement's current agenda is likely to come under attack in the coming years, Winkler added. That is really, that feels just great for all of us Second Amendment and freedom lovers. I think bans on assault weapons and bans on high-capacity magazines are ripe for the new Supreme Court with its newly invigorated Second Amendment to strike down. During Wednesday's oral argument, several justices expressed skepticism on whether New York has the right to limit carrying guns in public. Because again, what was New York State was saying was they were trying to basically limit for the citizens to own and carry guns in public with their permits, and they were trying to basically restrict the permit regulations, rules and regulations, and they were trying to make that subject to special need laws. This is what they were trying to pass. That was the hearing about. Currently, the New York law requires a public carry applicant to demonstrate proper cause, which is special need. The line of questioning from the court's 6-3 conservative majority hinted that the justices believe the law imposes an intolerable burden on gun owners' constitutional rights. Winkler, who specializes in the Supreme Court and the Second Amendment, said that while it's always hard to predict how the High Court will rule, it would not surprise anyone if the court were to strike down the New York law, given the recent appointments to the Supreme Court, who are basically strong pro-gun justices. This is the first gun case that all three of former President Donald Trump's Supreme Court appointees are hearing. And many conservatives have long anticipated that Justices Neil Gorsuch, Brett Kavanaugh, and Amy Coney Barrett will rule in favor of gun rights advocates' positions. You guys remember that these Supreme Court justices were handpicked by our President Donald Trump. Kavanaugh, who promotes the idea that only history and tradition, not public policy concerns, should be used when considering the Second Amendment, has recently been in the majority more than any other justice. On Wednesday, he signaled that he would side with the other right-leaning justices and help them secure the necessary 5 conservative votes. Justice Kavanaugh, who has written about the Second Amendment as a lower court judge, echoed some of his thoughts on Wednesday, Winkler said. He seemed to express significant doubt about New York's law and skepticism about whether the lower court had applied the right test to determine whether New York's law is constitutional or not. During New York Solicitor General Barbara Underwood's arguments, Kavanaugh said that the discretion provided to the officials who have the authority to approve licenses seems inconsistent with an objective constitutional right. Why isn't it good enough to say I live in a violent area and I want to be able to defend myself, he asked Underwood. Although the court's decision is not expected until spring 2022, experts warn that the ruling will have impacts on laws in 7 other states. Excuse me. There is a bunch of other cities that will feel the impact very quickly, Winkler said. If the court says that New York's laws are unconstitutional, which we know they absolutely and definitely are unconstitutional, then those states that have very similar laws are going to see their laws struck down pretty quickly too. That includes California, Massachusetts, and a variety of other states. Obviously, state of California and Massachusetts are particularly mentioned as 2 bastions of Democrat states, Democrat-infested, liberal-invaded states. Hannah Shearer, the litigation director at the Giffords Law Center, estimates that 25% of Americans, including those in Los Angeles and Boston, could be affected if the High Court was to strike down New York's law. If the NRA-affiliated petitioners succeed in getting the Supreme Court to recognize a broad right, I repeat, the broad right to carry concealed guns in public, gun rights extremists are likely to next target laws restricting open carry as well as laws allowing states any discretion to deny carry permits, even to people with dangerous criminal histories, like an arrest record for domestic violence, Scherer previously told Newsweek. Well, I can see where Scherer is coming from in what he's trying to do. Winkler urged the gun safety movement to begin shifting its agenda and move away from its current efforts in response to Wednesday's hearings. In quote, "It is time to stop focusing on banning particular kinds of firearms or accessories like high-capacity magazines or assault weapons and focus more on gun violence prevention programs, getting adequate funding for community intervention programs, lifting restrictions on the Bureau of Alcohol, Tobacco, and Firearms," he said. Again in the quote, "The gun safety movement has reforms it can pursue. Indeed, some of these other reforms have been pursued by the movements for years, but they've been sidelined as assault weapons bans and high-capacity magazine bans. More high-profile reforms take center stage," Winkler added. "I think that some of those other proposals and reforms are the wrong way to go today, given the Supreme Court," he said. That's, friends, that's an awesome article. These are awesome news, basically. Very encouraging. All the Second Amendment freedom lover people, all the law-abiding Americans who basically want simply to exercise their God-given and Constitution-guaranteed rights of bearing firearms, whether it's for protection, target shooting, hunting. Those rights, I repeat, are basically guaranteed and protected by the Second Amendment of the United States Constitution. I just want to share with you the link that I received basically with that email. It was saying you will be able to hear oral arguments live on Wednesday by going to this link. So when I tried that link before, it wasn't actually giving me access to the oral arguments. I'm just curious. I just want to click on this audio page to see if the hearings are available. And again, what was it? It was November 3rd, which is this. 20-843 New York State Rifle and Pistol Association versus Bruen. Let's click on this one.
We will hear argument this morning in case 20-843 New York State Rifle and Pistol Association versus Bruen. Mr. Clement?
Mr. Chief Justice, and may it please the Court, the text of the Second Amendment enshrines a right not just to keep arms, but to bear them. And the relevant history and tradition, exhaustively surveyed by this Court in the Heller decision, confirm that the text protects an individual right to carry firearms outside the home for purposes of self-defense. Indeed, that history is so clear that New York no longer contests that carrying a handgun outside of the home for purposes of self-defense is constitutionally protected activity. But that concession dooms New York's law, which makes it a crime for a typical law-abiding New Yorker to exercise that constitutional right. This Court in Heller labeled the very few comparable laws that restricted all outlets for carrying firearms outside the home for self-defense outliers that were rightly condemned in decisions like Nunn against Georgia. New York likens its law to a restriction on weapons in sensitive places. But the difference between a sensitive place law and New York's regime is fundamental. It is the difference between regulating constitutionally protected activity and attempting to convert a fundamental constitutional right into a privilege that can only be enjoined by those who can demonstrate to the satisfaction of a government official that they have an atypical need for the exercise of that right. That is not how constitutional rights work. Carrying a firearm outside the home is a fundamental constitutional right. It is not some extraordinary action that requires an extraordinary demonstration of need. Petitioners here seek nothing more than their fellow citizens in 43 other states already enjoy, and those states include some of the most populous cities in the country. Those states, like New York, limit the firearms in sensitive places, but do not prohibit carrying for self-defense in any location typically open to the general public. I'm happy.
Okay, so basically, friends, this is the total duration of this recording. The oral argument is almost 2 hours. It's very close to 2 hours. It's actually 1 hour, 57 minutes, and 2 seconds. And I just wanted to share this first 2 minutes and 20-second portion of it, just to kind of set as a reference to be able to share with everybody, to start kind of hearing how the hearing started. And we've been already going through on this Newsweek article what happened. So I'm gonna go back to that article. And I already I already completed the article. Which wasn't very long, but I think it was sane enough. So basically, going back to this portion here, this sentence, which is listing the names of those 3 Supreme Court justices, God bless them, Neil Gorsuch, Brett Kavanaugh, and Amy Coney Barrett. As you see, people, as you see right now, we owe this decision that came out of Supreme Court ruling because of our President Donald Trump's handpicked justices who squarely opposed all leftist, Democrat, liberal, shameless attacks on the constitutional rights of the American people. And they did, and they said what they said. They said what they're thinking. This is the decision of the Supreme Court of the United States of America. We know that as NRA members and friends of freedom lover people and the Second Amendment supporters, the faceless and shameless attacks of Democrats will not stop, will continue. That's why NRA, National Rifle Association, and ILA, Institute of Legal Action, will continue non-stop to fight against the liberal aggression and to protect the constitutional rights of American people. This is a great victory, and I basically wanted to share with everybody who loves the freedom, who respects the United States Constitution, who believes in the value of the Second Amendment, which I want to repeat one more time briefly. I hope I didn't close it. It should be here. I'm sorry, I think I was going to go a different page, but I don't want to take too much time, but you all know it. And it was a heartwarming decision coming out of Supreme Court, striking down the proposal by New York City. Was it any surprise that it's coming from New York City? Was it kind of any surprise that it's going to go also against the aggression from the extreme left California, state of California, the liberal aggression and non-stop liberal attacks on our constitutional rights. Same thing from Boston. And as this gentleman, those first 2 minutes mentioned, there are now 43 states, he said, that the anti-gun laws and all kinds of proposals and attacks on the constitutional rights, state by state by state, and within states, sometimes county by county, sheriff department by sheriff department, they are resisting, they are refusing, they are passionately rejecting the federal aggression coming out of Washington, D.C. What is that federal aggression? Elimination of the freedom to bear and carry firearms on her or his person. No matter how hard they attack, they will not be able to succeed, and the freedom love of people will prevail. That's what I wanted to share with you people. Thank you very much for watching this short video.